Arun sir, am I audible? Good morning, Arun sir. Can we start the program?
Yes, sure, sir.
Okay, good morning to all of you. I welcome you all to the one-day webinar on intellectual property rights under the Azadi Ka Amrit Mahotsav Innovation Week celebrations. The Azadi Ka Amrit Mahotsav is an initiative of the central government to celebrate and commemorate India's 75 years of independence. The celebration ends on 15th August 2022. In furtherance of the vision statement of the Honorable Minister of Commerce and Industry, this campaign aims to reach as many university college students as possible and equip them with the basic grounding in intellectual property. This program is hosted by the DPIIT Chair, Inter-University Center for Intellectual Property Rights Studies, CUSAT, in collaboration with Cell for IPR Promotion and Management, CPAM, Department for Promotion of Industry and Internal Trade, DPIIT, Ministry of Commerce and Industry. Before I move on to introduce the speaker for today's session, a couple of instructions for the participants. All participants are requested to mute their video and audio during the entire session. In case of doubts, comments, you can put it in the chat box, and at the end of the session, I'll read it out for the speaker to respond. At the end of the program, a link for giving feedback will be put in the chat box. I request all the participants to kindly fill it. For today's session, we have with us Mr. N. Subramanian. Mr. N. Subramanian is an electrical and electronics engineer who started his IP career as a patent scientist and as an in-house IP trainer cum analyst. He has vast experience in patent searching, drafting, and filing, handling IPR seminars, awareness programs, and framing university IP policies. He is a registered patent agent and is currently working at Cell for IPR Promotion and Management, DPIIT, as an assistant manager. Now, I welcome Mr. N. Subramanian to handle the first session. Over to you, sir.
So thank you. I will share my screen. Yes, my screen is visible?
Yes, sir, it is.
Yeah. So thank you. A very good morning to you all for the session on intellectual property rights organized by IPR chair of CUSAT and CPAM from DPIIT as part of the Innovation Week. So let's start the session. So the motto of the session, the half-a-day session is, you want to know what are the intellectual rights you have, be inspired to innovate, and protect your IP rights. So this is the motto of the session today. So first you want to know what all the IP rights you have. Once you know about those IP rights, you can be inspired to innovate. Once you come up with innovation, you protect your IP rights. So this is the motto today. Let's begin. What is intellectual property? So you know that if I have a house with me, so I say this is my property. If I have a bag or if I have a gold with me, I say this is my property.
Sir, sorry for the interruption, sir.
Yeah.
Are you actually showing the slide? Because it's not visible.
Slide is not visible.
No, sir. The screen is visible, but not the slide.
Okay. Now is visible? Thank you.
Yes, sir, it is visible.
So you know that you have the property with you, like a house, gold, and all. It's a property. Likewise, there is another property that is called the intellectual property. We normally called this intellectual property as IP. This is created based on our creativeness. So if we come up with some creative work by using our mind, that is also our property. That property is termed as an intellectual property. So there is a saying, imagination has no border. So if we imagine something new and come up with some new creative things, that is also our property. So it may be an invention, it may be a book or painting, or you come up with some new songs, images, or designs. It may be anything. So if you create something from your intellectual mind, that is termed as an intellectual property. Okay, what are the legal rights? So the government is providing some legal rights for those intellectual creations. That legal rights are termed as an intellectual property rights. And generally, these intellectual property rights are territorial in nature. What is meant by territorial? So if you get protection for some creative work, what you are doing, that is only applicable in India. If you need protection in different countries, you need to get protection in different countries. So generally, this IPR is territorial in nature, and there are different laws for each IPRs. Hope you are clear with intellectual property and intellectual property rights. Okay, what are the different types of intellectual property rights of that? We came across these words in our day-to-day life. Let's see each one. First one, we are going to deal about patent. Second one, design, copyright, trademark, trade secret, geographical indication, plant variety protection, and layout design protection. So these are all the different types of intellectual property rights or that you can protect your creative works. Let's see each one. First, we start with patent. What is meant by patent? It is an exclusive right granted to you for the inventor to exclude others from making your invention and selling your invention and using your invention, and they cannot import your invention also. So this is an exclusive right given to the inventor for their invention. So if you come up with any new invention, you can get patent for your invention, and that is the exclusive right for you. So without your permission, nobody can use those things. Okay, for an invention to be patentable, what are all the criteria you need to satisfy? Sir, I have an invention with me. So what are the criteria I need to satisfy to get patent for my invention? Your invention must be new. That means it is not existing anywhere in the public. So it may not be a blog, it may not be in any websites, videos, anything, journal publication. It could not be published before filing your patent application. That is considered as new. And second criteria is it has some inventive step. So your invention has some technical advancement when compared to the before invention, and which is non-obvious to a person who is skilled in the art. Who is skilled in the art? So take example, if you are doing some research in electric vehicle, So if the person who is skilled in that electric vehicle doesn't know that, that is termed as a non-obvious. And third criteria is your invention should be capable of industrial application. So that means you cannot get the patent for the theories. If you come up with any industrially applicable thing, at the time only you have the opportunity to get patent for your invention. And normally the patent is valid for 20 years. So if you get a patent for your invention, it is valid only for 20 years. Once 20 years is over, it goes to the public domain, so anybody can use that invention. Here, you cannot extend those 20-year term in patent. The patent is given only for 20 years from the date of filing of your application. Take example, if I am filing my patent application today in 2022, I will get the patent protection up to 2042, only 20 years. Beyond that, you cannot extend it. And this patent is territorial in nature. So if you get patent protection in India, you will have the right only in India. If you need protection in different countries, you need to file different patent application in different countries to get protection in those countries. Hope you are clear with the patent. Let's come up with one example. So we know Michael Jackson. So he come up with a dance that is called as an anti-gravity dance. Can you guess what is the invention from him? Yes, his invention is the shoe, what he is invented. So there is a base in the stage. In that base, there is a hitch. So he is taking his shoe in the hitch and he come up with the anti-gravity lean. So this is an illusion made by Michael Jackson by his invention. So this invention is patented by him. So no other dancers without him cannot use the shoe without his permission for the period of patenting. Some patentable inventions. Other examples like when we are going for a vote, we are having the ink. You cannot wipe that ink. So that is patented invention. And tractors we are using, clips we are using, these all are the patented inventions. Okay. But in India, we say inventions are patentable, but still some inventions cannot be patentable as per the Patents Act 1970. The Indian Patents Act 1970 excludes some inventions which are not patentable. Okay, what are the inventions? You cannot get the patent for the method of treating. So if you come up with a method how to treat humans and how to treat animals, you cannot get patent for it. And if you come up with the invention that cause serious prejudice to human and computer program or algorithms in India, you cannot get the patent protection for the computer program and mere discovery of a new form of a known substance. So take example, there is already a substance is available. If you come up with a new form of that substance, you cannot get patent if it doesn't say the efficiency. If you prove the efficiency, then you will get patent. If it doesn't prove the efficiency, you cannot get patent. And admixture. So if you are mixing the many particles and resulting with some properties without efficiency, you cannot get patent. And method of playing a game. So how to play a game, you cannot get patent. And presentations and inventions containing traditional knowledge. So if we take example, I am coming up with some invention by using neem and turmeric, you cannot get patent because it comes under the traditional knowledge. It is already known to the public. And the inventions which are contrary to the natural law. So take example, when some machines are manufactured, it is always less than 100% efficiency. But if you say that my machine is greater than 100% efficiency, it is against the natural law. So you cannot get patent for that. And mathematical or business method, you cannot get the patent for the mathematical method or business method. So take example, the business methods like Amazon, Flipkart. Business method is same. You cannot get the patent for it. And method of agriculture. You cannot get the patent for the method of agriculture and the inventions which fall under the atomic energy. So if you come up with an invention which is related to atomic energy, you cannot get patent for those invention. So these are all the some examples. You cannot get patent for the inventions. Okay. So now you know what is mean by patent and what are all the non-patentable inventions. Now you come up with the invention. What are the steps you need to follow to patent your invention? Let's see. First, you need to do the patent search. So, what are the already existing prior publications in the databases in the public domain? First, you need to do the search and see whether your invention is already existed or not. Once you do the search, you can come to the conclusion, okay, my invention is not there, or by using the documents which is already existed, you can improvise your invention. Then you want to draft your patent application. So once you know that your invention is new, you draft your patent application and file your patent application. So these are the three steps you need to follow to file your patent application. First, you need to do the search. By doing the search, you come to the conclusion your invention is not already existed. Then you want to draft the patent application based on the references you have. Once you draft the patent application, you file your patent application. Okay, so for doing the search, what are all the tools are there? I will give you some tools. So there is a tool called Google Patents. So in the database, you just go and give your keywords of your invention and you can search and it will retrieve the patent documents which is related to your keywords. And second database is eSpaceNet. This is an European database where you can search the documents. And third one is InPos. This is an Indian patent database. This database provides you the documents which is published in India. So what are all the patent application filed and published in India? You can get those documents in the InPos website. And fourth one is Patent Scope. This is a database of World Intellectual Property Organization. It will provide the details of the international application. So these are the some databases you can fetch the information regarding to your invention. And these databases are free to use. You don't need to pay any money to download the things or to see the information. You can see all the informations, the complete document. You can download the document. There is no need to pay anything. You can just go and give your keyword. By that way, you will get the documents. You can read the documents. You can download the documents and you can use the documents for your information. So these are all the databases you can explore to do the patent search. In Google Patents, how to do the search? You can use, normally we use and, or you can use that, and also you can use the wildcard truncations. Like if you doesn't know the take example, electrification. So you no need to use electrification as a keyword. You want to use electric star. So when you put star, it will give all the documents which is having the root word electric. And you can use question mark. So take example, in some words, COLOUR, color we are using. But in foreign countries, they are using COLOR. So at the time, you can use COLO question mark or, so that it will give the documents which is having you and also not having you. So these are the some strategies you can use to search the documents. And proximity. Proximity means the distance between two words. Take example, coronavirus. So corona near to virus, so that it will give the document which is having the corona and virus between two words. So these are all the some syntax you can use in the Google patterns. And next one is eSpassnet. So this is an effective database. So kindly use this eSpassnet when you are doing the final year project. Just to give your keywords there and it will give the pattern documents related to it. You can use the Boolean syntax like and, or not, and you can use the star truncations, question mark, and proximity. Here you want to give prox bar distance less than. You can replace n by 2 or 3 so that it will give the documents related to it. So eSpassnet is an effective database. You can use this database. You can download the documents. You can read all the information there. You no need to pay anything in this database. Okay, once we do the search in these databases, now you come to the conclusion, okay, so based on my search in the databases, there is no invention related to my work. Now you are going to draft your patent application. In drafting patent application, there are two types. So like when we finish our degree, they will give the provisional certificate. It's like a temporary. So within 1 year, you will get the degree certificate. Likewise, in patent application also, when you are at the initial stage of the invention, so now only you are going to start your research work or your project work, but you know the landscape, how the project is going to be. You can file the provisional specification as a temporary application. You want to give the details of the invention. This is the thing you need to file to secure the priority date. Because in India, who is the person first filing their patent application will get the priority. So once you come up with the invention, kindly file the provisional as a temporary one so that you will get the priority for your invention. And the patent office is providing you 12 months time period. So within the 12 months, you want to complete your invention and file the complete specification with claim section. So the claim section is normally called as the heart of the patent. What you want to claim in the session. So this only gives the legal boundary to you. So the claim section is very important in the patent application. So first you file the provisional specification in the patent office. You secure the priority date, and within 12 months you want to file the complete specification. Okay, what is the terms in the specification? It has title of your invention, technical field. So you want to say in which field your invention is. Take example, my invention relates to electric vehicle, particularly relates to battery management system. So it comes under electric vehicle, particularly to the battery management system. Likewise, you want to give the details and background of invention. So when you are doing the search in the databases, you come up with many documents. And you, when you are reading journal publication, you come up with some documents. You want to write those documents as a background. So these are all the technologies already existed, and this patent number talks about this publication talks about this. Likewise, you want to give the background of invention and what is the problem in the background. Then you want to give the summary. So what is your invention is, you want to give the summary of your invention and brief description of drawings. So if you have some drawings in it, you want to say figure 1 illustrates the 3D view of the electric vehicle. Figure 2 illustrates the controlling system of the battery management system. Likewise, you want to give the description of drawings. Then you want to detailedly describe your invention. So you want to describe what are all the methods you are using, what are all the materials you are using, what are the processes you are using. You want to give all those details in this detailed description of invention. Then you want to give the drawings. So you want to give the line drawings in the documents. Claims. So here only you want to claim. So I claim that a device which comprises of these things. Likewise, you want to claim in your invention. And finally, abstract. So these are all the subject matter you want to provide in your application. Patent application consists of all these things when you file the complete specification. Hope you are clear with the structure of patent application. Now you drafted the patent application. Now we are moving to filing our application. So what are all the forms? There are 30 forms are there. But for filing, these are all the some forms which is very important for filing an application. So what are all the forms you need to file? First one, form 1, that is a application. In that application, you want to give who is the inventor and what is the title of the invention and how many page your complete specification is like. You want to give those details. And form 2 is a provisional or complete. So you can file provisional or you can file complete specification with a detailed description of the invention. And form 3 is statement and undertaking. Statement and undertaking in the sense you want to say my I am filing the patent application in India. There is no other patent application related to it in any other countries. So if there is any patent application related to in any other countries, you want to give those details in form 3. That is called statement and undertaking of foreign filing. Next form is form 5, declaration of inventorship. So take example, I am a student in a college. My college is the owner of the patent because I am using the resources of the college or institute. So they are the owner, but I am the inventor. So you want to declare who are all the persons working in that project or working in that research work. That is called as a form 5, declaration of inventorship. The next form is form 18, request for examination. So once you file the application, there is a person in the patent office need to examine. So for doing the examination, you need to request for examination. And there is another form called form 28 for academic institution. If you are filing from academic institution, you want to ask, I am from academic institution, kindly give the concession in the fee. So these are all the forms you need to file, like form 1, form 2, form 3, form 5, form 18, and form 28. So these are all the forms you need to file in the patent office when you are filing your application. Okay, what is the fees you need to pay? Take example, if you need to file application through physical filing in the sense you can file to the patent office through paper. by sending the post to the patent office. It's called physical filing. Application fee is rupees 1750 if you are filing in physical mode. If you are filing in e-filing mode, then they will give 10% reduction. So you want to pay 1600. And examination fee is rupees 4400 when you are filing in physical filing. When you are filing in e-file, you will need to pay 4000. So that means if you are filing in e-filing mode, you want to pay 1600 plus 4000, 5600 as a fee to the patent office for your patent application. If you are involving any professionals to do the patent search, to do the drafting, to do the filing and all, then you need to pay for them separately. It doesn't comes under this. So the government fees is this only. Application fee is 1600 or 1750. Examination fee is 4000 or 4400. So this only you need to pay to the patent office. Nothing about that. Okay, what is the renewal fee? So once you file the patent application in the patent office, like paying the 1600 and paying 4000, they will do the examination and they will give it to you. But you know that patent is given for 20 years. So to make the 20 years active, you want to pay the renewal fee for every year once the patent is granted. So for first 5 years, you want to pay rupees 8,880 per year. Every year you need to pay rupees 880. From 6 to 10 years, you want to pay rupees 2,650 every year. From 11 to 15 years, you want to pay rupees 5,300. From 16 to 20 years, you want to pay rupees 8,800 every year. So these are all the fees you need to pay to maintain your patent. So if you doesn't pay the fee, then your patent document will get abandoned. Okay, we see what are all the fees. Now where to file patent application? So there are 4 offices in India, one in Kolkata, Delhi, Mumbai, and Chennai. So these are all the patent offices in India. So you are from, if you are from Kerala, you need to file the patent office in Chennai patent office. So you can directly file your patent application by sending the post to them, or you can directly visit the Chennai patent office and file your application. If you need to file in e-filing mode, you just go to this website www.ipindia.gov.in where you can file your patent application. Okay, once you file the patent application, what is the process will be carried out by the office? First, you are filing the provisional specification. Then you are filing the complete specification, that is within 12 months from provisional, and they are giving you option of withdrawing application. So you can withdraw the application within 15 months. And the publication, once you file the patent application, if you are not withdrawing, then it is automatically published in the patent journal after 18 months of your filing. If you need the publication quickly, so take example, I am filing my patent application today, I need within 1 month or 2 months, you can opt for yearly publication by paying the fee so that it will publish quickly in a month. So once it is published, request for examination, then the patent office will do the examination. The patent examiner who is in the patent office, who is well versed in your technology, they will do the examination. and they will give the examination report to you. So in the examination report, it consists of whether your invention is a non-patentable invention according to Indian Patents Act, whether it has novelty or non-obvious, and they give some documents related to it. So based on the report, you want to reply, and your reply must be within 6 months. So they give a time period. You want to reply within 6 months. It may be extendable for 3 months. That's it. If it doesn't reply, then your patent gets abandoned. You need to reply within 6 months, or it can be extendable by 3 months by paying a fee regarding that. If your reply is okay, or they will conduct some video conference hearing with you, and the controller will ask the questions based on their examination, and you want to give the reply to that. That's it. So once the hearing ends, finally they will give the grant of patent. So normally it takes 2 to 3 years to get a patent in India. But if you are from the academic institution, you can opt for expedited. So fast, like how yearly publication happens, you can go for the expedite examination, so that you will get the patent within 1 year or 2 years. So this is the process followed by the patent office to grant the patent. So this is the patent certificate you will get. So the patent certificate consists of patent number, who is the inventors, and what is the title of the invention, and how long they can use this patentable invention. So this is the thing you have in this patentable certificate. So hope you are clear with patents. So far we see about what is meant by patent, and what are all the forms you require to file patent, and what are all the databases you can do the search to fetch the patent documents, and how the patent certificate looks like. Hope you are clear with the patents. Now we are moving to the next one, design. Okay, what is a design? It is a shape, or it may be any pattern or arrangement in any article in a market. So if we take example, when I am seeing any product, what is the aesthetic appearance? The appearance of the product is termed as a design. And this design, if we need to get protection for the design, your design should be applied in any article by industrial process. That means if you come up with a design in a paper, you cannot get the design protection. You want to apply that design in an article. If you apply the design only, you will get the design protection. And it is registered for 10 years. Can be extended for 5 years. That means design protection is provided for 15 years only. You cannot extend after the 15 years. Once 15 years is over, anybody can use the design. What are the essentials of a design? It should have an eye-catching feature, it should be a new one, and it should be applicable to an industrial process, and it should not be any artistic work like painting, sculptures. These and all doesn't comes under the design. You want to have a design that is eye-catching feature, and it should be applicable to an article. If you have the design like that, you will get the design protection. Like you can see this example. So we are using helmets. What is the difference between the every helmets? The materials they are using, that comes under the pattern. But here you can see the aesthetic appearance, the look. So the look can be protected under this design protection. So every company, they are protecting their outer appearance of a product under this design. You can see in the helmet, you can see the design number. Here also you can see there is a number inside the helmet. That number is termed as a design protection number. Okay, what is the registration procedure of design? First, you need to file the application form, Form 1. There is only one form here, and it is in the design wing Kolkata, or you can file in the design office like Chennai, then they will transmit it to the Kolkata. Once you file the application, they will do the examination. So what the examination they did, they will check your design and they will check the classification of design. So the design office, they have some classification. What type of product you are using. So they will check all the classification and what is the design, what is the product and all. Once they are okay with that, then they will issue the design certificate to you. So what this design certificate consists of, the design number, who is the designer, and what is the title of the design, how long they can use it. So once you get the protection, now it's yours. Design offices, Delhi, Kolkata, Chennai, and Mumbai. So same offices are there. If you need to file design application, you file in the Chennai office. If you need to file in e-filing mode, just go to this website www.ipindia.gov.in. There you can file your design application. Okay, what is the fees I need to pay? If you are an individual, you want to pay an application fee of rupees 1000. If there is any professionals are there, you need to pay them. And if you are from any organization like big companies and all, they need to file with the fee of rupees 4000. So this is the fee they need to pay to the design office to get protection for their designs. So hope you are clear with the design. So design is simple, like the aesthetic appearance of a product. So if you come up with any new aesthetic appearance of your product, you can get the design protection for it. For that, you need to file the design application in the design office. They will do the examination and finally they will give the certificate to you. Hope you are clear with the patent and design. Now we are moving to the next one, that is copyright. This is most interesting topic for us. Copyright. What is in by copyright? It is an exclusive right given to the creators for their literary work and artistic works. Okay, once you get the copyright, what are the rights you have? So if I am the owner of the copyright, I have the exclusive right in the sense I have the right to reproduce my work, I have the right to translate my work, adapt my work, perform my work, and publicly display my work. So these are all the rights as a copyright owner I have. What are all the works comes under the copyright? So it may be any literary work, like if you come up with any books, poems, anything, and computer programs all comes under the literary work. And artistic work like paintings, sculpture, photographs, these all comes under the artistic works. And some music, sound recordings, and any films, cinematographic films, these all comes under the copyright. And when you take copyright, the registration is not mandatory. So if you come up with the once you come up with the work that is yours, there is no need to get the copyright protection, copyright registration for it. It is not mandatory. But getting the copyright certificate registration is a strong proof. So it is not mandatory. Once you come up with the work, that is yours. But getting the copyright registration certificate is a strong proof. Because these are the works covered under copyrights, like literary, including softwares also comes under the copyright in India. Books, essay, compilations, and computer programs, artistic work in the sense, drawings, paintings, logo, maps, chart, photographs, work of architecture. These all comes under the artistic, dramatic. So if you come up with any drama, screenplay, drama, and musical notations, sound recordings, and cinematographic films. So these are all the works covered under the copyrights. Okay, how long this copyright belongs to? So take example, if you come up with any literary work, if you write a book, so how long you will get the copyright? So the copyright is belong up to the lifetime of the author. So up to your lifetime, the copyright belongs to you plus 60 years. So after the lifetime of the author also, it goes to their legal heir. So their family members or their legal heir, they will enjoy the copyright up to 60 years after the lifetime of the author. And for anonymous and pseudonymous works, so if he doesn't know the author name and all, at the time also it is protected for 60 years from the year that was published. And for sound recording, 60 years from when the sound recording is published, from 60 years, like a film. So if you take a film, if a film is published today, they will get the protection from 60 years from today, so 2022 to 2082. So this is the term of protection as an author get when they get the copyright. So here you can see the example. We are seeing the film like Harry Potter. So this is a film based on a book. So the author J.K. Rowling, she write 8 series of Harry Potter book. So once she write all those books, she will have the copyright in it. She will give the license to some publication company so that they will publish these comics and they will sell it. By that way, she is earning money out of it by selling the books, and she is giving the same story to a film production company, and they will give the sum of amount to her. So you can see a single story can be transformed into a readable material and also the visuable material. So by that way, she will earn lot of money and she will become a billionaire. So this is the power of copyright. If it doesn't get the copyright protection for your works, then anybody can use it as a free and you doesn't get any recognition in it. Okay, what is the procedure to get the copyright? First, you need to file the application in the copyright office. Once you file the application, they will issue a diary number. So the diary number consists of what the number. Once you file the application, they will give the number to you. That number is termed as a diary number. And there is a procedure of 30 days mandatory waiting for objection. So they are putting your title of your work in the website and they are waiting for objection for 30 days. If anybody is objecting your work or not, if any objection is filed, then the registrar will decide to accept or reject those objections based on the hearing. And then there is a scrutinization by examiner. So the examiner in the copyright office, they will examine your application and they will issue the discrepancy letter. So what are the discrepancies in your work? And you want to reply within 45 days of receipt of letter. You want to reply within 45 days. So once your reply is gotten by the registrar, they will have the hearing and they will approve the registration, and finally they will give the copyright certificate to you. So it normally take 3 to 6 months or within 1 year you will get the copyright certificate for your work. So what is the website you need to file? So if you need to file the copyright application, you need to go to this website copyright.gov.in. There you can file your application. So the office is only at Delhi. So the copyright office is only at Delhi. You need to file the e-file through copyright.gov.in. You can go to that website and you can create your username, password, and you can file your application. So what is the procedure? What is the file? So there is only one form. That form is form 14. So you can see the form in the website. So that form consists of statement of particulars and statement of further particulars. That is form 14. What is the statement of particulars? So you want to give who is the author and what type of work is that, what is the language, all the things you need to give in that application. And you want to provide separate application for everyone. Take example, if you write a book, that book consists of 6 volumes. You want to give the separate application for every volume. So if you come up with a song, if your album has 6 songs, so you want to file separate application for every song, and each application should be signed by the applicant, and you want to pay the request fee to the registrar of copyrights through e-payment. So what is the fee I need to pay to the registrar? You need to pay rupees 500. So if you need to file any book, poem, or any drama, music, or any photograph, anything, you want to give that work and you want to pay rupees 500 and you want to file that application form 14. If you come up with any sound recording, then you want, that is a CD, compact disc, you want to pay rupees 2000 if that is any film. So if you take any new film, you want to pay rupees 5000 to get the copyright protection for that film. So this is the certificate. So once you get the copyright protection, they will issue the certificate with the C symbol and who is the author, what is the title of the work, and what type of work is that, and what is the language of the work. They will give all the details in this copyright certificate. Hope you are clear with the copyright. So now let us take some break for 10 to 15 and then we will back another IP.
Sir,
Yeah,
hope the first session is over.
yeah, we will
Okay.
go with this.
Okay. So thank you, sir. I think Arun sir, we can join back after 15 minutes if the first session is complete.
Yes, okay, sir. We can go on like that.
Okay. So
So maybe we'll start by 11:10.
yes, sir, we can do that.
Okay, okay, sir.
Okay. Thank you.
Okay, thank you. Came back by 11:10. We will start our second session. Yeah. Shall we start the sessions?
Arun sir, we can start the session, right?
Yes, sir.
Yes, sir.
Okay.
I will share my screen. Is my screen is visible?
No, sir.
No, sir.
Yes, sir. Now it is visible. Sir, now it is not visible, sir.
Ah, I will sharing later.
Okay, sir.
Now it's okay.
Okay, sir.
Okay. Okay, welcome back. So in the previous session, let's see the summary of the previous session. We dealt about what is an intellectual property and what is the intellectual property rights and its types like patents, designs, and copyright, and its registration procedures. So now we are going to continue that. The next IPR we are going to discuss is trademarks. So what is a trademark? So this is the term we hear everyday life. It is a mark which distinguish one product from another product. That type of mark is termed as a trademark. So it may be any name, or it may be a word, it may be a sound, color, or symbol which differentiates your product or your service from others is termed as a trademark. So here you can see examples like Coca-Cola, BMW. So these are all the marks which it differentiates their product from others in the market. And this trademark is given for 10 years and it can be perpetually renewed. That means you want to renew it for every 10 years. And this trademark is termed as an unlimited time IP. Trademark is used for long years. So take example 100 years of Britannia, 100 years of Tata. So they are using the same name for 100 years. First they want to get the protection for 10 years, then they can renew it for every 10 years. What are the essentials of a trademark? If you want to get trademark, so what are the essentials? So it is an advisable one. So your mark should be a unique one. You cannot give the general term. You want to give some unique name. Examples like Doordarshan. And your trademark should be distinctive. So it should be distinct from others, like Beam and VHF. And your trademark should not be a dictionary word. It should be a non-dictionary word. You cannot take the words which is from dictionary because it's already known to the public, so that you cannot differentiate your name from others. And you come up with some new devices or you come up with some new design of your logo, symbol, and your trademark should be a non-descriptive one. You cannot describe your trademark in your logo. It should be a non-descriptive one. So these are all the things we advise when you come up with some new name for your company or when you come up with some new service. And what are the things you need to avoid? You need to avoid the adjectives like good, super, efficient. You cannot write these adjectives in your trademark, and you no need to give the name of the person or places because it is already known, it's common, so you cannot distinguish, and you cannot use any religious symbols and common shapes. So these are all the things you need to avoid when you frame a trademark for your company. How to indicate your trademark? So this is the wordings we see when you are going to shopping or anything. You can see this mark TM above the logo and R in the above of the logo. What that means? So TM means it is an unregistered trademark. So they are filing application for getting trademark. That is termed as a TM. It is an unregistered trademark. And R is the registered trademark. So when somebody is putting TM, so they say that their registration is under process. When somebody is putting R symbol on above their logo, they say that their logo is registered. So this is the difference between TM and R symbol. So these are the some examples of logos. What is a registration procedure? Simple. You want to file an application, that is TMA. What is a fee? You want to file the application TMA. Once you file the application, in that application you want to give the details like name and what type of goods you are going to sell or what type of service you are going to provide. Based on that, they will classify your application. They will do the examination whether that name is already existed or not. Once they do the examination, they will publish in the trademark journal and waiting for objection. If nobody is objecting, then your registration is approved. So it takes up to 6 to 12 months to complete the whole registration process for your trademark. So the trademark certificate. So this is the trademark certificate they are providing to you, which consists of the logo and the name of the proprietor and what type of goods you are going to sell and what is the name of the company. All the details are there in this trademark certificate. Where are the trademark offices in India? So there are 5 offices in India: Delhi, Kolkata, Chennai, Mumbai, and Ahmedabad. So if you need to file trademark, you want to file in the Chennai office. You want to go to the same website www.ipindia.gov.in. There you can file your trademark application TMA by filing the fee of rupees 5,000. So this is the fee you need to pay. So if you pay in physical mode rupees 5,000, if it is an e-filing mode, they will give 10% discount 4,500. So this is the fee you need to pay to the trademark office for getting the trademark registration for your logo, name, or anything. Hope you are clear with trademark. Now we are moving to the next one, that is a geographical indication. So this is a tag given to a product which has some specific geographical location or origin. So take example, there is a Matta rice is the Wayanad coffee. So these are all the products which are specific to the geographic origin. That type of products are protected under the geographical indication. This acts as a certificate. This is a indication provided by the government which says that it has some certain unique quality and you cannot buy those products in any other places. It is unique to that region. And this geographical indication is provided to protect the interest of producers, because many producers, they are belonging to the origin and they only depend on that product. So the government is taking the step to protect those products and give them high gain when they go to the international market. And this geographical indication can be filed only by the producers. You, geographical indication is not given to any single person. It is given to the collective persons, like a producers. So the producers need to file the application for their product and they want to get the protection for those products. So like Mysore silk, Naga mircha, many products. So you can see many products in Kerala which is having some unique quality because of the geographical origin. So for those products, government is providing this geographical indication tag. What are the essentials? So if you need to get the geographical indication, what are all the things they need to satisfy? It may be an agricultural product like spices, pepper, Malabar pepper is there. It's an agricultural product. Or it may be any natural product like granite, marbles, or it may be any manufactured product. Manufactured product in the sense it may be a foodstuff, it may be a handicraft, it may be anything, but it should be originating from a definite geographical territory. Navara rice, Wayanad coffee. So you can see that Wayanad coffee you can get only in Wayanad, specific geographical territory. And they consider, so any one of the process, whether it is the production or whether a processing should be taken in that place, that they considered for geographical indication. Once the product gets this GI, it conveys that it has some quality and it has some distinctiveness when compared to the other product. And this GI promotes the economic prosperity of the producers. So once they get the GI protection for their product, the value of the product is very high in the international market because it has uniqueness, it has quality in it, and this GI is valid for 10 years. First they give for 10 years, then they can renew it for every 10 years. That means it is also an unlimited life IP, but they want to renew it for every 10 years. So this is an example, Tanjore doll. So this is the logo used by the government for the products who are all getting the GI tag. So they say this GI as an invaluable treasures of incredible India because these are our treasures. We are using these products for more than years. So this is the treasure. So to protect those treasure, government is providing this GI tag. So if your locality having these type of unique products, you can ask the organizers to go for this GI protection. So what is the procedure? First, they need to file the application form GI-1A. So in that application form, they want to give the statement of case. That is, what is the uniqueness of product and what is the history proof from which year they are using these product in the region. And they want to give the map of the region. They want to give the details of producers. So what are all the producers who are all producing those products? They want to give the details. So once they file this application form, the GI office, they will do the examination, they will check the application details and they will classify the GI product. So in the sense, whether it is agricultural product or natural product or any foodstuff or handicraft, anything, based on that, they will classify it. Then they will issue the examination report. And the organizers, they need to reply within 2 months. Then they will publish in the GA journal, and they are waiting for opposition for 4 months. They are waiting for opposition. If nobody is opposing, then finally they will issue a GA registration certificate to those producers. So once they get the GA registration certificate, they can use the GA logo in their products when they are selling, so that they will get higher profit when they go to the international market, because their product is unique and you cannot get that product other than that. So this is the certificate they are providing, which has name of the product and the producer association name, and if any logo for the product, they can use the logo and time period. So this is the process followed by the geographical indication registry. Where is the office where they need to file the geographical indication? There is only one office in India, headquarters at Chennai. So if anybody need to file geographical indication, they need to file their application at Chennai office, or they can go to the website www.ipindia.gov.in. There they can file their geographical indication application. What is the fee? So the application fee is rupees 5,000. So the producers need to file the application fee of rupees 5,000 with their application and the history proof, map, all the things, and they want to file. So once they file the application, they will do all the examination, and finally they will give the GI certificate to the producers. Hope you are clear with geographical indication and trademarks. Now we are moving to the next one, that is the plant varieties protection. In India having the special type of legislation to protect the farmers' rights. Because India is an agricultural country, more people are dependent on agriculture. So to protect the farmers' rights, Indian government they come up with the India's Protection of Plant Varieties and Farmers' Right Act in 2001 to protect the farmers for their new variety of plants. So if a farmer come up with a new variety of plant, they can protect it under this system. So we cannot get any patent for the plants in India. We only have this protection to get for the plants in India. So the farmers can get, and plant breeders, so who are all breeding the plant varieties, they can also get the protection. To get the plant variety protection, what are the criteria? Your variety should be novel. If you come up with a new variety, and it should be distinct from the other variety, and the propagation, the serious generation of propagation should be uniform, and it should be stable. Based on the climatic condition, it want to be stable. They will check all these factors, then only they will provide the plant variety protection. So for plant variety protection, what are the steps they need to go? So if you are a farmer, if you need to get plant variety protection, you want to apply to the plant variety authority, which is in Delhi. You want to give the seed in the packet, and they will check the DUS test. That is, they will check distinctiveness, uniformity, and stability of the seed. And based on that, they will provide the plant variety registration. Now we are moving to the next one, that is the trade secret. So what is my trade secret? So any confidential information. So if you have a company, every company have some confidential information. That only gives them the competitive edge when compared to the other players in the market. So that type of competitive edge information are termed as a trade secret. It may be an R&D information, software, algorithms, inventions, designs, consumer profiles, and ingredients. We don't know what the ingredients they are using. Advertisement strategies and policies of a company, everything. So these are termed as a trade secret. And this trade secret can be protected for an unlimited period of time because they are keeping it secret. So how long they have the information in secret mode, they can protect it. But there is no specific law to protect this trade secret in India. We have different laws, but there is no specific law like a contractual law and the breach of confidentiality. We have separate laws, but there is no specific law to trade secret in India. The next type of protection is semiconductor integrated circuits layout design. When you come up with an integrated circuit, so take example, now we are using gadgets and computers and all. When you come up with a new design of the IC chip, you will get this protection. And they will see your design should be original, your design should be distinctive from others, and it should be capable of distinguishing from any other layout design. So they will check all these factors, and it should not be commercially exploited anywhere in India before filing your application. After checking all these things, they will give the registration to you. So this will give the registration for 10 years. So once 10 years is over, anybody can use the layout design. So you will have the right up to 10 years. So kindly see this, you will come up with a clear conclusion. Let's see. You can apply this knowledge in your field. I will give you simple. When you convert, you have an idea. When you convert your idea into an invention, then you can go for patent. When you convert your idea into an expression in the way of a poem, in the way of drawing copyright. When you convert your idea into any appearance of the product, design, when you convert your idea into any identity for you. So like when you start a new company, when you are providing new service, that is the identity trade. So these are the four IPs is majorly created by you, because when you convert the idea into these type of words, you will get these type of protections. Let's give some example. If you need to get patent, what you want to do? You want to come up with any new process or any new device, new model. If you come up with these type of words, you will get patent protection for it. Or you come up with any improved process. Already existing the process is there. If you come up with any improved process or improved device, improved model, you will get the patent protection. So here you can say algae lamps. Algae can be used for lighting up. So this is one type of invention. So if you come up with the invention like this, you will get patent protection. For copyright, if you come up with the scientific articles, if you write a book, or when you are college they come up with some manuals, software code, if you come up with any databases, you will have the opportunity to get copyright protection. So the institute, if they come up with any manuals, they can get the copyright protection for their manuals. If you write a book, the author can get the copyright protection for their book, software codes, databases. So these are all the things you will get protection for copyright. Design. So when you are working in labs, you come up with many equipments. When you have a new design of the equipment, or when you come up with any new design of the products, what you are looking. So I'll take example any jewelry, watch, water bottle. So what are the products you are looking? When you come up with any new design of it, you can go for design protection, trademark. So if you start a new company, the trade name, or if you launch a new product name, when you are providing new service marks, these all comes under the trademark. So you can protect those names under this trademark, trade secret. So if you don't need to reveal your things, like what are the formulas you are using, what are the processes you are using, what are the software code you are using for database and compilation of facts, if you don't need to reveal the information, you kept it confidential and it comes under the trade secret. So now it's in your, so you know what are the different types of IPs. Now you want to choose which type of IP you can protect for your work. Whether you want to be a secret one or you want to go for patent